This week, I'm just going to talk a little bit about trust accounting because it's definitely, if you're a legal bookkeeper, it's going to be your number one item that you want to talk to the attorney about and ask a lot of questions. There's few things that are vital to running a successful law firm as much as having an effective trust account management system in place. It plays a pivotal role in ensuring ethical compliance. So, what trust account is, you're holding funds that don't belong to you. They're your client's funds, and they're prepayments basically for work that you're going to do in the future. And the Bar Association has the heavy hammer here that makes sure that everything is held compliantly and that you don't misappropriate any funds at all. So, unfortunately, there's been some statistics recently that are a little bit troubling. There's a trend of mismanagement with trust accounting. And sometimes it's just the fact of not deliberate mismanagement, but a lot of times it's just the attorneys maybe don't move the money out of trust. They're afraid of making a mistake. Have, they don't want to move the money out because they're afraid that they're not accurate. Their trust account becomes out of balance very quickly, especially if they don't have a tool in place to track it, like a Clio or a lien law. And what happens is a lot of times they leave it in place, and I've heard it called a little buffer, or I just didn't move it because I want to make sure that I have enough money in that account. So when I do have to move money for other clients, but you can't keep money there if you've earned it. That's the thing. So sometimes the out of compliance piece is just a matter of that. The money's sitting in trust. They haven't moved the funds, even though they've earned it. And that is also making your account out of balance, out of compliance with the bar, and it can be a heavy duty problem. So, 25%, approximately 25% of lawyers that face disciplinary actions, uh, and that relates to any mismanagement that happens annually. So, 25% of all attorneys at some point will face a bar audit and will have to explain what is little snippet window that the bar decides is going to audit you, what was in the fund. So if you have $10,375 in that bank account, you need to account for all of that with all the different uh, people that money that you're holding grouped together equals that amount. And that's the thing we have to make sure that we do. It's an interesting concept because it is something that we see a lot of times. The attorney will say, well, I just put the money in there and I used all, I always bill myself. When I do the billing, I just leave it zero. I apply all the funds, and so it's zero. And maybe once in a while it's not that way, but I don't really need to track it. You do. You do, because the bar can come and say, I want to know what was in the account on the 15th of the month. And then if you do it in the beginning of the month and you clear it, but then there's money from the current month, there's still an accounting that has to take place. So for compliance, and I'm just going to go over a few of the key compliance requirements. You need to keep a complete separation of the client funds, and you have to keep it separate from the operating. So it has to be the funds that come in that are trust related, that are going to be held in trust, have to be in a trust type bank account, IOLTA bank account, something of that nature. You have to regularly reconcile this bank account. You can't discard it and say, I don't really care about it. I'm going to take all those funds every month anyway, so I'm not even going to track that in my bank, on my QuickBooks. Yes, you have to track it. And just balancing it on QuickBooks is not a way that's not reconciled. You need the three-way reconciliation. So you need to show the balance that's in the bank account plus or minus any transactions in transit that happen while, the end of the month ended, and then you've got some uncleared checks or uncleared deposits. And then you have to match that up to the trust bank account balance in QuickBooks, and then also that liability, the ledger account, all the individual ledger accounts that equal that total, all of that has to equal. And we like to um, break it out as a liability account, sub-liability accounts of a master funds held in trust liability account. And we collapse it and make sure that balance matches the bank balance on the books. And then you want to have a detailed record keeping of all the transactions. If somebody happens to put a deposit that was supposed to go into trust into operating, and you have to make a few transactions to show that properly on the books, lots of notes, because the bar might come and calling and wanting to reconcile you, but it's not going to say, let's do it for yesterday's date. It's going to pick a date. And you better have notes in there to understand what happened if that happened to be the case that somebody put the money in the wrong bank account. So non-compliance of trust and the rules around trust account for 15% of all disciplinary actions against lawyers. So the bar will put a disciplinary action against the attorney, and some of them can be very, very stringent. It could actually put their professional license at risk. The consequences can be monetary, but it could also lead to disbarment. So you have to know that there's quite a few different scenarios there. You just want to make sure that everything is done properly. How do we fix this? Best practice, make sure it's reconciled. If it's not reconciled and you know it and there's something wrong with it and you don't know how to fix it, hire a professional like one of us that can, advise the attorney, you gotta hire me. Make sure it's correct. You gotta blow that whole balance sheet up for all dates and do it by year and figure out when was the last time it balanced and then go from there cleaning. Don't go backward to clean it. Figure out the starting point, the last time it balanced and go forward. Ask the attorney, where do you keep your three-way bank reconciliation? A lot of them look at you like deer in headlights. They didn't realize that that's part of their compliance piece. California in particular has very strict rules, so you really want to make sure that wherever your attorney is practicing law, you look up those rules. Use specialized software. You get a software like Lien Law, you put that money in, and then you can't take more money out than was put in. So you're protecting yourself there. So it's really important to do. So having those practices in place, if there's cash coming into the office, have a cash process too for your staff so there's no impropriety or chance of anybody keeping any of the cash and it doesn't make it in the bank, especially when you're talking about client funds. There's a heightened amount of regulatory scrutiny. I can just imagine with AI, we might be seeing more audits than instead of less as these things start to speed up and we're able to do some of this stuff very, very in an automated way. So law firms need to prioritize tracking trust. They need to be diligent about their trust management and account management and use modern technology to assist you to make sure that you can mitigate any chance of a mistake. Really important, don't ever reconcile the bank account and say, oh, it's off by $2 and throw that in reconciliation discrepancy. You shouldn't do it overall, but when it comes to trust, it's a no-no. Never do it. Find that $2. Being proactive is ultimately going to build a stronger reputation for the law firm, and it's also going to foster a stronger relationship between you and the attorney. I hope that helps, and we'll see you all next week. Bye now.